Welcome to Resolutions, the official podcast of the American Bar Association section of dispute resolution. Every episode is a journey into the heart of conflict resolution, guided by our diverse community of experts. We're here to explore innovative strategies, share wisdom from the field, and inspire excellence in resolving disputes. Whether you're a dispute resolution professional, a curious learner, or someone passionate about fostering understanding and peace, you're in the right place. Let's dive into today's conversation and discover how we can transform conflict into opportunity together.
Welcome to Resolutions, a podcast about dispute resolution and prevention. This podcast is a project by the ABA section of dispute resolution to increase the avenues where we can connect. I'm Dr. Larry Schooler, one of 4 section hosts who serve as interlocutor, engaging in conversations with members of the dispute resolution community about topics of interest in the field. This week, I'm sitting with the Honorable J. Michelle Childs, one of the keynote speakers at the ABA's 2026 Arbitration Institute. You'll find more information on the Institute in the show notes. Judge Childs was appointed to the U.S. Court of Appeals for the District of Columbia Circuit in July 2022. She holds degrees in management, law, personnel and employment relations, and judicial studies, along with an honorary doctorate in public service. Judge Childs has worked in private practice as Deputy Director for the South Carolina Department of Labor Licensing and Regulations Division of Labor, and as a commissioner on the South Carolina Workers' Compensation Commission. In 2006, the South Carolina General Assembly elected her as a state circuit court judge. She served as Chief Administrative Judge for General Sessions, which is South Carolina's criminal court, and as Chief Administrative Judge for the state's business court. In 2010, she was appointed to the U.S. District Court for the District of South Carolina, where she served until her appointment to the D.C. Circuit. Well, Judge J. Michelle Childs, welcome to Resolutions. It's so nice to have you as our guest.
Thank you for having me.
You know, normally we talk about something other than litigation, which is the main part of your daily work. And so I'd love to just start with knowing what led you to want to participate in the Arbitration Institute that the Bar Association Dispute Resolution section is putting on. You'll be one of their speakers. What attracted you to be part of that program?
Well, I got asked by Brent Clinksdale, who's apparently one of the co-chairs of the event. And I always enjoy being around lawyers, particularly seasoned ones and even younger ones, and learning about subject matter that comes through our courts. And it gives me the opportunity to learn just as much from them as they expect to learn from me, because they are on the cutting edge of the issues within any particular subject matter. And it helps me to learn what is at tension with them, and then to make sure that in our rulings, there are not unintended consequences. So it's very helpful to learn from the experts as well.
I think some of our listeners who are seasoned practitioners in the field will be able to easily identify points of intersection between the courts and arbitration. But I wonder if you could just help some of our less educated listeners maybe understand that a little bit more, because obviously when someone takes a matter to arbitration, they assume that an award will be final, but I know that the court can often play a role in enforcement of that. Can you just talk a little bit more about the ways you see the two forms of dispute resolution, courts and arbitration, importantly intersecting?
Certainly. As someone brings a case to court through litigation, particularly in federal courts, and we are courts of limited jurisdiction, you're expecting to have all of your claims resolved, particularly by one single judge. So there's some similarity there in that you would be with the panel on arbitration, and those claims would go through the course of the pleading stage, having evidentiary issues dealt with the judge, potentially a trial, dispositive motions along the way, and then potentially going to a jury who then has the ultimate decision about the case. The judge will make rulings, as I indicated, along the way, and then there's an opportunity for an appellate process. As you go through arbitration, it's usually that arbitrator who's making a lot of decisions about the specifics of the arbitration. And in many instances, cases will come to our court But if there's an arbitration clause that requires it to go another place, then we will make that decision there, but not on the substance of what's at issue in the arbitration.
To what extent is a court like yours or the federal judiciary ever called upon to enforce what has been agreed upon in arbitration? I understand you probably wouldn't get involved in evaluating the award or, was it properly rendered? But I can anticipate that something is worked out in arbitration, but then subsequently is being dealt with on the implementation side. I wonder, is that something that either your
Yes.
court specifically or other courts deal with? And what does that look
Yes,
like?
that has come in federal courts, but it's also come, and I'm at the DC Circuit Court of Appeals, it's also come in the standpoint of arbitration on an appellate level as well. I mean, we've handled cases, for example, international arbitrations going on in Africa or some other countries, and there are certain strands of the arbitration that may come through us in an appellate process.
Do you can you sort of help our audience also identify, you referred to jurisdiction here just a minute ago, and I think it may or may not be obvious what some of the boundaries and limitations are between, say, courts and arbitral tribunals. You referred to international. I mean, of course, you're unlikely, I would think, to hear a case that involves people from multiple nationalities in the sense of activity that takes place outside of the U.S. But help us understand a little bit more about kind of those boundaries in jurisdiction between courts and arbitral panels.
Well, usually for the federal courts, there's diversity jurisdiction, so you can have cases heard between states, citizens of different states, and so those would end up in our court on just any regular litigation, basically giving the parties supposedly a fair opportunity, so that if there's perhaps a corporation who's housed somewhere else, that they're not getting what you consider as home cooking by being at the state court where everything's so local, and having this foreign corporation, so to speak, come in that regard. But the arbitration panels literally exist around the world, in terms of the international arbitrators trying things in various different jurisdictions. And then that tends to matter, because then you have to think about what rules are they going or being governed by and too. But a lot of times that's a choice of law issue that's part of the arbitration agreement as well.
I want to be careful here. You're, of course, a sitting judge, and I don't want to ask you to opine on things that could come before you. But I do, as both the host of this podcast and also as a professor who teaches about different dispute resolution processes, I do wonder your thoughts about when cases that might have been intended for litigation end up being just as well suited for arbitration, which is to say, most of the impulses, I think, of people who are in a dispute is, well, I'll see you in court. That's their kind of their reflex. And yet, of course, we know that arbitration and mediation have played increasingly significant roles. Do you have any just thoughts around, here's a certain type of dispute that someone may bring to court that you've seen get worked out, efficiently and thoroughly in an arbitration setting?
Well, I would say that generally speaking, people end up in arbitration either by choice, because that's the form that they've selected as an alternative dispute resolution, and then sometimes not by perhaps a knowing choice, because maybe it's the credit card agreement that nobody reads that forces them that way, and it puts them in a situation where that's the binding arbitration dealt with by that panel or a single arbitrator in that regard. So I think there are certain instances where people will feel that that's a much more efficient process, as alternative dispute resolution tends to be. Mediation would be more of an agreement between the parties to forego the litigation process, but instead be in mediation. But I think it's more for those disputes where people have either agreed or there is something that they have signed off on from a contractual relationship that forces them to that forum.
And again, trying to steer clear of asking your opinion, but more just empirically speaking, I just wonder, from your vantage in terms of the workload of your court and of courts generally, do you have any sense as to whether folks may start to say, gosh, I'm waiting, months or some inordinate amount of time to be heard in court, and I really am it's in my best interest to opt into an arbitration type proceeding? I mean, do you see that
Well,
workload rising and the need for something like that?
Well, I mean, you have multi-district litigation, for example, taking up 40% of the federal docket. That's a very high number. And there are certain federal judges around the country who are taking that on, but they still have their regular docket to get to. And so I can see in perhaps maybe a products liability situation where there's going to be several people in a particular class, or there's certain business disputes that, lend itself again to classes, and you not wanting a different resolution per forum, that arbitration might be the way to have a panel deciding some of the big issues for all of the class.
And so I understand you're imagining a panel of practitioners from multiple states potentially and something like that.
Yes,
Yeah, that's
yes.
very interesting. Is that something you hear about a lot, or is that less commonly deployed in an arbitration situation?
I think it's probably less deployed in arbitration in terms of several panels from different states, as opposed to coming up with an arbitration panel that would handle it for all the states. Just like on the litigation side, you'll have one multi-district litigation judge specifically handling all the matters, all the claims that might be going on in 20 something states. And that comes through the multi-district litigation panel selecting the particular judge to handle those matters.
That makes sense. Do you experience any, for lack of a better word, friction between the arbitration processes that may be adjacent to anything you're hearing and the litigation that's taking place? Is there anything that you're noticing in terms of, I don't know, the conduct of particular arbitrations that's then becoming a challenge when it hits a court docket, or a court has made certain rulings and then that gets somehow garbled, I don't know, in an arbitration setting? Are there any points of friction that you think need to be addressed by?
Yeah, I think a lot of it just tends to go to what was the agreement about in terms of just even trying the case. Like, what are the due process issues in terms of fairness, in terms of the discovery, the document? Obviously, in the US, it tends to be much more litigious in our setting in a federal court or any other court setting versus the arbitration process that's probably more panel led in terms of what is going to be utilized in the proceeding, in terms of any review of documents, statements, and things of that nature, which is much more broad in litigation.
This is a little bit of just a personal interest question of mine, but I've done a lot of my mediation work in a public policy setting, so helping a government, find consensus amongst, stakeholders in that regard. And it occurs to me that maybe appellate courts less so, but certainly the federal courts are being placed generally in a lot of settings where they're having to evaluate public policy these days.
Mhm.
Whether it be executive orders, whether it be other kinds of action taken by other branches. My question to you is, to what extent do you think the courts are well suited to do that work? And to what extent is any of that fit for arbitration? Or is arbitration really for, an entirely different kind of dispute that doesn't involve those kinds of issues?
That's a very interesting question, because we are, generally as judges seem to be more tasked now with legislative intent, for example, when we're interpreting the statute or things of that nature. And I think the arbitrator is more suited for what was the intent going into the arbitration. Like when that agreement was signed, what was the intent for what is to be resolved there, and under what circumstances in terms of what tools you can utilize to get that resolution.
So it sounds like, when it's action being taken sort of unilaterally as compared to an agreement freely
Yes.
signed by parties, the courts may be best positioned. Whereas if it is a willfully drawn up, multi-party agreement, then an arbitrator could be more
Much
suited to
more
that.
helpful. Yes.
It's also interesting to me, just from my vantage point, to see circumstances in which a normally private proceeding like arbitration becomes public. For example, there are employment circumstances like with a police suspension or firing, where that arbitration may end up being publicized. And of course, your work is generally, done in broad daylight. Do
Mhm.
you have any thoughts about the pros and cons associated with the usually complete privacy of arbitration as compared to circumstances in which it might become a public matter?
I think, and we wrestle with this even on the civil side for litigation about closed proceedings generally and things being sealed off to the public. And from the litigation standpoint side, courts are very careful about what closed proceedings can be, and it's not impossible, obviously, because there will be some. But you're very sensitive to those issues because we do believe the public ought to have an eye on us and that the proceedings ought to be very transparent. If the parties have agreed to arbitration, again, this is coming into an agreement of a situation that they've put their capital into in the sense of what they want to occur in that particular proceeding. But I do think that under certain circumstances, for example, I mentioned products liability earlier, if there's going to be an agreement about something that happened with a bad product or something, then that's something that the public would want to have the right to know, and those kind of things should not be sealed off.
Mm. Quite an interesting, dilemma in some respects, because I know, at least from my perspective, often corporations, especially multi-state, national kind of corporations, benefit from the arbitration process based on its efficiency and perhaps its privacy. But what I hear you saying is, yes, and I mean that there could be circumstances in which there is a compelling public interest associated with that arbitration outcome that needs to be at least in some way discussed publicly. Am I understanding you right?
Yes, that's correct. That's correct. And then, some of the privacy interests might also feed into whether or not, after the fact, is the corporation cleaning up the spill, or if there's some, rationale for why what they're doing about the imperfect product and things of that nature. If there's something very legitimate about the process that particular arbitration panel believes is important to keep secret, then I think there's some flexibility in that process as well.
One other thing that occurs to me to ask you about is notions of what I would call procedural fairness. I mean, I'm sure it's been
Mhm.
called by other terms, but of course, in a criminal proceeding, obviously, someone is entitled to legal representation and due process and the chance to be heard. You're hearing civil cases, but there are obviously opportunities for the sides to, I would assume, exchange evidentiary matters and things of that nature ahead of time. How, if at all, do you think about notions of procedural fairness, both in your court, but also in an arbitration context where that feels like it's a little less tightly controlled, I would think, than in a court?
It's important that resolution by a neutral person, meaning judge or arbitrator, it's only effective if you have all of the information. And so procedural fairness to me is having, full access to whatever the information is. And it comes in a better form if you can have a party represented, obviously, too, because you want to not be advising them of their rights and opportunities within any particular proceeding. So I would say it comes in two forms. One is representation at the table with able counsel, but then also having access to all of the information that is necessary to make the decision.
Well, and that, of course, brings up a fascinating other element of this, which is obviously the cost of representation. And
Yes.
I won't ask you to take a position on whether counsel should be provided in a civil matter, but I would imagine that certain doors might be metaphorically closed to someone in an arbitration setting because of the cost just of retaining counsel for something like that.
And that happens on the civil side as well. Obviously, if it's a criminal matter, then we have laws or rules or constitutional rights to have appointed counsel. But on the civil side, there generally is not, unless there's some extraordinary circumstance. And usually the monetary value of the case lends itself to counsel stepping in to represent. On the civil side, too, there are a lot of pro bono attorneys who do the work, either for the experience or for assisting with a resolution that might have a a beneficial outcome. So I would suggest that system might be employed on the arbitration side too, for people who need experience and then will just assist in the cases. But then also there's something beneficial to be gained, so they'll take it on a pro bono basis,
That
or
makes a lot of sense.
or some type of financial incentive in the case.
Absolutely. Yeah, that makes a lot of sense. Have you come across ethical issues in arbitration that you think are worthy of the attention of the folks coming to the Institute? Are there things that either directly come to the court or just things you've become aware of that you think arbitrators really need to be sensitive to ethically?
I think in any forum, people need to be reminded of the rules of professional responsibility. And that includes whether you have any conflicts, with certain issues. And that's for the arbitrator as well as the parties that are appearing before them, so that all of that can be resolved, early on. And then you are having the right people and the arbitrator appear in the cases appropriately. And then that could also be with how you share information, like not hiding the ball, what information should be privy to all parties who are involved in the matter as well. And so mostly those types of things is the conflicts and the information sharing.
I hope that you will take this question in the way that I intend. Please forgive me if not. But I can't help but wonder, as a person who is likely underrepresented, I would say, across the federal judiciary. To what extent do you think? Do you have specific thoughts about ways in which that should change? And also in the arbitration context, I've not looked at data, so I'm flying blind here, but I wonder if you have thoughts about ways in which that needs to evolve, whether it be in recruitment of neutrals or in some other fashion to create broader representation, if you will.
Well, certainly, I believe that when panels are being selected, really the parties should give some consideration to all types of diversity, whether it's geographical, whether it's big firm, small firm, whether it's young lawyer, seasoned lawyer, whether it's gender, race, etc. Because that only makes the system itself better when there can be diverse perspectives added to the situation as well.
I appreciate the reminder to our audience how diverse diversity is, so to speak. That's very
Yes.
important. I would be remiss if I did not ask you whether the idea of being an arbitrator yourself has ever crossed your mind.
Well, I have a few years left before I would finish out my term to go to my lifetime compensation. But there will be things such as this that I would consider. It seems very fitting and suiting to come from being a judge on a trial court, both state and federal, and then even part of a panel now on the appellate court to consider this opportunity as well.
Well, not to speak for any of our arbitrators, but I suspect they will keep a seat warm if you would like to sit in it at the appropriate time.
Well, thank
but
you.
but with that, Judge J. Michelle Childs, we're so grateful that you took some time and glad you'll be part of the Arbitration Institute as well. Thank you for joining us.
Well, thank you as well. And I look forward to being part of this program, and that for you all to have a wonderful audience ahead of us.
Thank you for joining us on Resolutions. Today's episode has illuminated the powerful impact of effective dispute resolution and showcased the incredible individuals who dedicate themselves to this important work. Our mission is to explore the diverse world of dispute resolution, and we hope we've inspired you to engage with conflict and collaboration in new ways. If you're not yet a member of the ABA section of dispute resolution, we invite you to join our community of professionals making a difference. Your involvement can help us build a more harmonious society together. And if you found value in our conversations, please consider leaving us a review and a 5-star rating wherever you listen to podcasts. Your feedback helps us reach more people and continue our journey towards excellence in dispute resolution. Until next time, keep solving problems, building bridges, and creating positive changes in your communities.